Congratulations, you have a trust. Now what do? Your trust will not serve its purpose unless it's properly funded. This video discusses the basics of funding a revocable living trust. This is not legal advice, but a general overview of trust funding for informational purposes. A grantor who establishes a trust funds the trust by placing property into it. A grantor may place most types of property into a trust, including bank accounts, stock and brokerage accounts, real estate, businesses, intellectual property, and personal property, like artwork and furniture. Specific types of trust may be designed to hold specific types of property, and some types of property may not belong in some types of trusts. Your trust only controls the assets that you have funded or transferred into it. If you don't transfer any assets into your trust, the trust is empty or unfunded. Such a trust controls nothing and is fundamentally useless. Similarly, a partially funded trust controls only the assets that were transferred into it, not other assets that the grantor intended to put into it. If the grantor becomes incapacitated or dies, a probate court action may be required to fully fund the trust. Furthermore, the grantor's property may not be distributed according to the grantor's intentions even after a probate proceeding. Assuming you have a typical revocable living trust, you fund your trust by changing how you own your assets from your own name as an individual to your name as trustee of your trust. For example, John Doe will go to the bank and change ownership of his accounts from John Doe as an individual to John Doe as trustee of the John Doe Family Trust dated October 29, 2024. A certification of trust, which can be as short as 1 or 2 pages, provides the information needed to change your ownership of assets when funding your trust. Let's consider several types of assets and how they should be funded into a trust. You should sign new signature or ownership cards to retitle bank accounts or cash equivalents, including treasury bills, money market accounts, and certificates of deposit, to change ownership of the accounts from yourself to yourself as trustee of your trust. Your certification of trust provides all or most of the information banks need to fund the accounts to your trust, but banks will have their own forms and procedures as well. Typically, there's no reason to add your trust to your printed checks. If you hold publicly traded stocks and bonds that are already in brokerage or investment accounts, as with the cash accounts, contact your brokers or custodians to change the owner of the accounts to yourself as trustee of your trust. You can name your trust as the payable on death or POD beneficiary of some accounts. However, POD designations become effective only when you die. They can be a pain for those managing your finances if you become incapacitated. You transfer your real property into your revocable living trust by signing and recording a deed changing title ownership of the property to your name as trustee of your trust. The deed must be recorded in the real property records of the county in which the property is located. Professional guidance is invaluable when recording deeds. An improperly prepared and recorded deed can have massive unintended consequences. For example, a deed might trigger documentary transfer taxes, capital gains tax, gift tax, or estate tax. In California, a deed error may also trigger reassessment and result in much larger property tax bills. After funding your property to the trust, contact your insurance company to add the trust as a named insured to your policy. Tangible personal property refers to such items as furniture, appliances, works of art, vehicles, collectibles, clothing, and jewelry. These are things you can pick up and move or drive around. If an attorney prepared your trust, your personal property probably has already been funded into the trust. Either the trust itself includes a declaration stating that you are transferring your personal property into the trust, or you signed an assignment transferring personal property into your trust. Vehicles can be titled in the name of your trust, but estate planners typically advise against that. Why? If you get into an accident, you don't want the other persons involved to think you must be wealthy and therefore a good lawsuit target because you have a trust. Also, the departments of motor vehicles in most states make it easy to transfer vehicles after someone dies. The types of business and the terms of the business documents determine how to include your business interests in your estate plan. Some business interests can and should be transferred into your trust. For example, single-member LLCs are easily transferred into your trust. Other business interests cannot be transferred into your revocable living trust. For example, some multi-member LLCs, partnerships, and closely held corporations include provisions in their business documents that restrict or forbid the transfer of interests. Professional limited liability companies or professional partnerships cannot be owned by a trust because they must be owned by professionals. For example, a professional partnership of doctors must be owned by doctors. Revocable living trusts may be the beneficiaries of life insurance policies. It's best to leave insurance funds to some beneficiaries in trust rather than directly. For example, if you wish to benefit minor children, naming them as direct life insurance beneficiaries can cause problems. If you have an estate that is heavy in real estate or other assets that may take time to sell or require maintenance, then an insurance policy provides an excellent means of funding your trust with liquid assets. The life insurance policy beneficiary designation, not your trust, controls the disposition of policy benefits. You must contact your insurance carrier to name your trust as a life insurance beneficiary if that's advisable. You cannot transfer the ownership of a tax-qualified retirement plan or individual retirement plan into your revocable living trust. A trust can be the beneficiary of a retirement plan. However, naming your trust as beneficiary of a retirement plan requires careful analysis, especially of potential tax consequences. For the most part, spouses maintain the most flexibility and better tax results by naming each other as beneficiaries of their retirement plans. After the spouse, subsequent possible beneficiaries must be examined on a case-by-case basis. You should review your estate plan with an attorney every 2 or 3 years to be sure everything is properly funded to your trust. Changes in your assets or changes in tax laws may require revisiting your trust funding. I'm Daniel Van Slyke, attorney at law. For more on estate planning, subscribe to this channel, I Plan Law, and check out my other videos.